She's representing Bank of America.
Yes. Merrill Lynch merged into Bank of America.
Okay.
You have them on
Yeah. I'm gonna put you around in just one sec.
the I hate seeing how old
We all don't look like we do when we turn around.
I'm trying to figure out whether they've even got a trust whenever, looks like everything goes to Mr. and Mrs. Wynn.
Yes, they do. Trust. Not gonna be offered.
Huh?
Trust will not be offered.
They're just named as a representative.
Yes.
All right. Ms. Thompson, can you hear me?
I can. Can you hear me?
Okay, so, if I can get you to raise your right hand, please.
Mhm.
Do you solemnly swear or affirm the testimony you're about to give in this call should be the truth so help you God?
Yes.
Okay, go right ahead, Mr. Jones.
Ms. Thompson, can you state for the record your full name as well as your position there with Bank of America?
Yes. Caitlin Cosbar Thompson, and I am a Vice President for Bank of America, Estate Settlement Officer.
Ms. Thompson, have you read the proof of death and other facts in this matter?
Yes, I have.
Okay. As you recall, we're probating a copy of the will because the original will was we were unable to locate. Is that correct?
Yes.
Have you read the proof of death and other facts?
Yes, I have.
Are they true and correct in every way?
Yeah.
Okay. In the event that you are named, your firm is named as the executor of the will, will you fully comply with the requirements thereof and execute the oath of office?
Yes.
I have no further questions, Your Honor.
Okay.
Unless you do.
Who's gonna identify the will?
Me.
I have your,
I just signed it
Who's got the proof of death and other facts?
right here.
Okay, had you ever seen the will, Ms. Thompson, before?
Yeah. Just the copy of.
Okay. All right. Thank you. I'm not gonna take any action today because we'll await the receipt of the proof of death and other facts in the oath.
Okay. Sounds good.
And we'll, move forward with taking care of Mr. Yo.
And once you need to get the oath and your proof of death and other facts notarized,
Mhm.
send them to our office and we will file them with the court.
Sounds good. We'll get that taken care of today.
Okay, thank you.
we have a status conference with Mr. Brink.
Okay.
You have a good day.
We're done.
All right, Mr. Celeste.
You don't have anything.
Thank you, Mr. Yo.
Thank you, sir.
Thank you, Mr. Rose.
Thank you.
Have a good week.
Good morning, Judge.
Good morning, Mr. Celeste. How are you?
I'm okay. Neil, can you hear us?
I can't see him or hear him.
Neil, you're gonna have to turn on your video. There he is. Can you hear us, Neil? Neil, can you hear us? You may need to turn on your volume. I need to give him a call here. Let's see here. I look like he was connecting to audio.
Yes,
Can you hear us, Neil?
I can hear you now. I apologize.
No, that's okay. How are you this morning?
I'm doing well. Thank you. How are you?
Yeah, I'm going okay. All right, Judge, I think we're ready. Just to kind of preview things, Judge, that Neil's father is the decedent. Father named his dad to be the executor, and then Neil's uncle as the alternate. Grandfather is deceased.
Understand, but the will was made 40 years ago.
Yeah,
So, yeah, gotcha. Everybody, I assume his grandfather predeceased his father.
he did, and then his uncle, who was the alternate, has declined to serve, and that's been filed with the court.
All right. All right, Mr. Rigney, can I get you to raise your right hand, please?
Yes, sir.
Solemnly swear or affirm the testimony you're about to give in this call should be the truth, so help you God.
I do.
Okay, Mr. Rigney, I have the original of the will, so I'm gonna ask you, do you recognize this as being the last will and testament of your father, Martin Rigney?
Yes, sir, I do.
And I'm gonna go back to the signature page and ask you, if you recognize his signature on that document?
Yes, sir, I do.
And to your knowledge, after the date he made this will in 1984, did he ever change it or revoke it?
No, sir.
Okay, go right ahead, Mr. Celeste.
Okay, Neil, prior to the hearing today, I sent you your proof of death and other facts, which you acknowledged receipt via email. Do you remember those documents?
Yes, I do.
And did you read those documents?
Yes, I did.
And is everything therein true and correct to the best of your knowledge?
Yes.
Okay, so what I'm going to ask you to do, Neil, is you'll need to print those out and you'll need to take them in front of a notary, sign them, get them notarized, and scan and email them back to me. And then I'll e-file them with the court so that judge can sign the order admitting the will to probate and appoint you as the executor. Okay?
Okay.
Okay, so make sure you sign them Neil Emerson Rigney, because that's the way you're referred to in the will.
Okay.
Once he file those and gets those back to me, I will sign the order admitting the will to probate and granting you letters of independent administration with the will annexed. And those letters will authorize you to take care of all the affairs of the estate and distribute the property or sell property, whatever you need to do. I'm also gonna have my clerk send Mr. Celeste this guide to forward to you, hopefully by email, so it explains how the probate process works and what your duties and responsibilities are. Take some time to review that, make sure that you cooperate with Mr. Celeste in doing an inventory, which needs to be filed within 90 days of the date I signed the order, okay?
Excellent. Thank you, sir.
All right, y'all have a great week. Thank you.
Neil, I'll talk to you soon.
All righty. Thanks.
Any more?
Not my signature.
Zoom.
We have a small state affidavit by Zoom. Show costs. But. I don't think it's show up.
Okay, I didn't see,
It's not really, show costs, we just did a notice of hearing. Try to get some of those estates moving forward, and he was gonna do it by Zoom.
the attorney,
Mhm.
okay, is it one that just hadn't done anything?
Yes.
Okay,
Mhm.
okay. Mr. Mayo, you want to come up? She took my papers from Mr. Mayo's. All right, Mr. Bennett, can you hear me?
I can.
All right, Mr. Bennett, I kind of set this on kind of a show cause to dismiss for one of prosecution because apparently when the ad litem's report was done, they identified another error, but we've not had any amendment of any of the pleadings in the case to take any further action. And I'd like to see that action taken. It looks like dad at 93 years old, lived at 7080 Calder. That's Calder Woods. So she was in a nursing home. Had $70,000 worth of stocks and bonds. And had two sons and apparently another one that had passed away.
Yes, Your Honor. What occurred in this one is I was trying to help out a couple of 70-year-old men who had a mother who died in her early 90s with only a single asset. As part of Mr. Lambert's investigation, we found out that there was, in fact, another brother that the brothers failed to tell me about, to be perfectly frank, who did have a daughter, but the brother said that he had basically disowned his daughter in his will. And so I was like, okay, well, I need a copy of the will. Well, apparently there's only one person in the family that has that will, lives half their time in Canada, half their time here. I said, is there any way that we can get this out of the safety deposit box so I can get it to Mr. Lambert so he can finish his report? I've been trying to do that for quite some time. My understanding is the keys have been FedExed to some family member in Colorado. They're supposed to get them out of the safety deposit box this week so that I can get a copy of this will to Mr. Lambert so that he can evaluate that and we can make the determination as to whether or not there are, in fact, only the two heirs, or if we need to make an amended pleading to fix this, to add this Tessa Cherry to the pleading. Tessa didn't know her grandmother, had never seen her in more than 40 years before her death. So that's what we're trying. That's what we're trying at right now to get done. I do apologize that it's taken longer. This was not something I anticipated, but I got a feeling we're going to have this completed in the next 2 to 3 weeks maximum.
Yeah, well, that's a good question. And if the father disinherited his daughter,
Who did he leave? Who did he leave his residue to? That's the question that no one seems to know.
well, does that ipso facto cut off the inheritance right of the daughter through the grandmother? I don't, because obviously had they had testamentary instruments, the father could have disinherited his daughter, but the grandmother could have still left everything to the granddaughter. I don't know what the answer to that is. It makes a good law school question.
It definitely raises some questions, but in the way that Mr. Lambert and I were feeling was until we saw the will of the deceased brother, we really couldn't dive into it because we'd want to see what his wishes were and would have been. And then from there, we can make a recommendation to the court.
Okay, I'm going to set this off 4 weeks to allow you the opportunity to get that before the court, and we'll reschedule this in 4 weeks and hopefully have it resolved in advance of that.
Yes, sir. Thank you very much.
Thank you. Have a great week, Mr. Bennett.
All right. Bye-bye.
Thank you, Mr. Lambert.
You're quite welcome. Judge, I have a draft if you want to see it. It's simply a draft of who I've talked to and who I've spoken with. I didn't address the issue of whether the grandmother's will